Houston Maritime Attorney. Offshore injuries are both common and devastating when you are or a loved one has been injured offshore. It is important for you to know what your rights are and what you are entitled to receive as comprehension. When you work with Rich Beanstalk, you can rest ensured that you will be working with a maritime injury lawyer with over 30 years of experience. That automatically ensures that you will have a leg up in court, as almost nothing is more important than experience in a courtroom. Contact as Houston Maritime Attorney as soon as possible for your claim. When an insured injury has occurred, it is important to understand what type of compensation you may entitled to. Offshore injuries are governed by complex and complicated state as federal law, which govern the type of compensation you may receive. For this reason, as experienced maritime injury lawyers such as those at Rich Beanstalk will help you tremendously with your case. For a free consultation, please call or fill out our online intake form. A brief history of maritime and admiralty law. Maritime law and admiralty law are two terms that can be used interchangeably. Importantly, maritime law, also called admiralty law, is what governs offshore accident. Maritime works have almost always adhered to certain scientific law that govern that their industry. Although much general maritime law in the United States come from the consideration that are other sources for their resolution as well. Below, we list some of the most important law, statutes, and resolutions that are crucial when it comes to maritime injury as the Jones Act, also called the Merchant Marine Act of 1920. The Jones Act extends the Federal Employers Liability Act (FELA) to injured maritime workers. Basically, it allows injured workers in the maritime industry to file personal injury claims against their employer. In order to do this, they must have been injured during the course of their job duties. The crucial status states the following: a seaman injured in the course of employment, or if the seaman dies from injury, the personal representative of the seaman may elect to bring a civil action at law with the right of trial by jury against the employer. Law of the United States establishing coverage for personal injury or death of a railway employee apply to an action under the section. Longshoremen and Harbor Worker Compensation Act, Death on the High Seas Act, Limitation of Liability Act, seamen's right to maintenance and cure.